In this video, we are going to do a brief overrun of kind of what the criminal case process in Coweta County, Georgia looks like. It's pretty similar to this throughout the entire Coweta Judicial Circuit, but there are some scheduling differences among the judges, and everything's always subject to change based upon the judges' orders and wishes, because they are in control of their calendars and their courtrooms. So we're going to go through about the 9 or 10 general steps in a case. The first thing that initiates a criminal case in almost all situations at the state level is an arrest. Someone's called 911 or an officer witnesses some sort of crime, an arrest is made. After that arrest, there is usually a first appearance that's supposed to happen within 72 hours. And sometimes, depending on the crime, there can be a bond set, when there's a booking or at the first appearance. And that's for a different discussion, talking about schedules of bails and things like that. But the arrest and first appearance process is your first chance at getting a bond, and in some cases you're automatically going to get one based on the schedule. If you're not given one, then the next thing that you will be put down for is a preliminary hearing, and along with that preliminary hearing, you can also ask for a bond at that point. These happen in magistrate court, so that is a lower court than where the case usually ends up. We're kind of talking about felony cases here, by the way. And the purpose of that preliminary hearing is to determine, the magistrate judge's job is to determine whether or not there's probable cause to send the case up to Superior Court, where felonies are handled here in Georgia. At that preliminary hearing, you can also usually have, you're granted the opportunity to be heard on bond at that point as well. 99% of cases at the magistrate court level at that preliminary hearing are, at least some of the charges are bound over to Superior Court for the case to initiate in Superior Court. Now, after that prelim and it's bound over to Superior Court, the next typical step, if there's still no bond, there's another chance to ask the Superior Court for bond at this point, and we'll talk more about that. You can check out the videos on bond and listen to some of the distinctions about and rules about if 90 days pass, getting a bond and things like that. But after that, there's usually a lull. If you still don't have a bond, there's kind of a gap here where this is the most frustrating times for people. After the arrest, the first appearance, the preliminary, there's a gap in time before formal charges are brought in Superior Court. And in Superior Court, formal charges are brought one of two ways, either one by indictment or two by accusation. Some crimes are allowed to be brought by accusation and can be brought by a grand jury indictment, whereas some crimes, especially more serious ones, must be brought by a grand jury indictment. Now, when a formal charges come from an accusation and indictment, that really gets the process started and the court dates start rolling. And your first court date is going to be what's called an arraignment, and you will get notice for that in the mail. Now, arraignments are treated wildly different across the different counties and jurisdictions in the state of Georgia. In many jurisdictions, the attorney can file what is called a waiver of arraignment, where neither the attorney nor the client must show up, and it is just given a new court date that we'll get to in a minute. For instance, in misdemeanor court in Coweta County, you can do that. However, felony court in Coweta County, the judges do not permit waivers of arraignment. You must appear in court with your attorney. If you don't have an attorney, you most certainly need to appear. If you do not appear, even if your lawyer's there in Coweta County, there will be a warrant issued for your arrest. And we run into this problem sometimes where lawyers assume that their clients don't need to come to arraignment, but that is not the case. In Coweta County, the client and the lawyer are expected to be in court at arraignment to be arraigned. Now, the typical customary process is simply, when the case is called, for the lawyer to waive arraignment and plead not guilty. And that moves us to the next phase, which there's an important thing that happens around that time too. In Coweta County, it is customary that your discovery will become available at the time of your indictment or arraignment. It's usually available to be picked up at your arraignment date. So after the arraignment, like I said, almost always there's a not guilty plea and a waiver of the formal arraignment. A formal arraignment is where the judge reads the charges out loud in front of the courtroom. It's tedious. It's usually waived. Very few times are there legitimate reasons to have a formal arraignment. So then we go to a series of non-jury calendars, and those are can be used for a variety of things. They can be used to hear motions. They can be used to enter into a negotiated plea deal if the case has if the prosecutors and the defense have come to some agreement. They can be used to enter non-negotiated pleas, and we'll talk about that in a different video about the difference between what we call blind pleas, which are non-negotiated, and negotiated pleas. They can be used, like I said, for a variety of things. They are status checks to see what the process of the case is. Your defense attorney may need to subpoena some records or something like that to one of these non-jury dates. After non-jury dates, the cases are moved to a trial calendar. Now, a lot of places, some places, trials are called just in order that cases come on the calendar. So if you're number one on the trial calendar, your case is expected to go to trial first, right? That is not necessarily the case in Coweta. Typically, the prosecutor's office in Coweta County, the district attorney's office, comes up with some sort of top list, whether it be top 5, 10, 15, whatever it may be, and those are kind of the target cases to be tried by the courts during that trial term or trial week. A lot of times, Coweta will have 2 judges available at least to try cases. Sometimes they'll even bring in judges elsewhere to try a 3rd case. So that is really the full case process boiled down into about 5 or 10 minutes, all the way from an arrest to a plea or a trial. And everything like that has, there could be an episode, a video on every single one of those things, probably multiples, but that is the general case process. Again, it's arrest, first appearance, prelim, bond hearings, indictment or accusation, and arraignment, discovery review, non-juries, and then jury trials. That's 9 things. Those are basically the steps in a criminal case here in Coweta County and throughout most of the Coweta Judicial Circuit.